Let's get the legal aspect of this now. Speaking to Attorney Mpumelelo Zikalala from Zikalala Attorneys. He's been kind enough to make some time for me this morning. Mpumelelo, good morning to you. And while I understand we're about to have two titans, the former president and the current president, we're now combining legal and politics. It does come down to this non-prosecution certificate. And just for the dummies like me, please help me understand, why is that so important? It can get lost in all the grey of this court case. Explain to me why that's so important.
It's important because that's a certificate that gives former President Jacob Zuma the right or the ability to go and prosecute any individual that he deems fit or that the NPA has authorized or has declined to prosecute in his matter against Advocate Belly Down and other accused that may be included, as it is attempted to include the current president, Mr. Ramaphosa, in this particular case. The issuing of the certificate is governed by the Criminal Procedure Act from Section 8 up until 19, and it basically means the NPA has declined to prosecute after looking at all the sequence of events and the evidence at hand, and they are saying, if you want to continue with your own private prosecution, you can go ahead. We give you those blessings. However, us as the NPA, we are not going to prosecute. Now, you can't do that if you don't have the particular appropriate certificate. And once you start those proceedings, that means the private individual is then clothed within the NPA robes, and they're able to do whatever that the NPA would have been able to do in the normal course and scope of prosecuting any offense that has taken place.
As an attorney, how difficult is it, in your opinion, Mpumelelo, going to be for the court to make a decision and how they word their judgment on this? Because, as we've just heard from the attorneys in the courtroom, if the current president were to appear in court, that could be irreparably damaging politically as a result of what the former president does. We can't separate the politics from the legal here as well. And this is where courts always have to sit on the outside, a neutral party. Would they need to address something like the political damage?
They look at it holistically. In fact, what they look at, they say, we want you to concentrate on these 4 points. Is there a legal right that needs to be protected? If we do not give the appropriate relief which is sought by the applicant, in this case the president, is he going to suffer irreparable harm? That's where you have to fill in the meat or fill in the gaps in terms of saying, what is irreparable harm that you are referring to? Can you provide examples in which I, as an independent evaluator or person who's going to take the decision at the end of the day, can really see that this is a matter of life and death? There's absolutely no way in which this person is going to be able to survive from it. It is not within the normal course and scope of any criminal matter that takes place when one becomes the accused and then becomes innocent at a later stage. So what irreparable harm are we actually dealing with in this particular matter? And that it has to show from the papers that you have submitted. But another point which is then looked at is that, are there other alternative remedies that you can go to, or dispute resolution forums that you can traverse before you come to court? In this case, there's an actual defense in the Criminal Procedure Act under Section 106, which deals with the no title to prosecute. So there are ways and mechanisms in which you can be able to defend your matter at a later stage. You just want, or you do, maybe you are getting the impression that you just want to jump the queue and have your matter heard on a special basis rather than following the queue and waiting for your turn. Another point is on a balance of probabilities. Are you going to win ultimately at the end? That mostly concentrating on Part B. Now, in this case, the odds are in the favor of the president in terms of Part B, because the president is not in the line of disciplining allegedly misbehaving prosecutors. That's the job of the National Director of Public Prosecutions, and maybe the minister in certain instances, and even the Legal Practice Council, if you so wish to go within that particular route. So if you separate what was being dealt with yesterday, Part A, which is agency, I would say the president is a bit limping on that one, because there are two elements that are missing. The irreparable harm, maybe it was not clearly traversed, or enough evidence was provided as to what is the actual irreparable harm that's going to be suffered. But most importantly, the alternative remedies, the appropriate matter or court to listen to this matter would be the criminal court. Now, another question which comes into play is jurisdiction. What gives the civil court authority or higher ground to decide this particular matter that the criminal court would have not been able to discuss? So if a defense is available, there are judges within the criminal court that will be able to look at this matter. They will even be able to recognize the rights which are applicable to the president, as the rights which appear to the accused are considered by any criminal court that sits there. So we are not dealing with a court of technicalities that simply looks at criminal matters. They also look at your rights as an accused and are able to make appropriate orders.
Let me ask you this in closing, Mpumelelo, if you don't mind. So, which either way this goes, we're only going to find out again next week. This is now the High Court. Is there going to be room for appeal on a case like this by either the president or the former president if either one of them don't agree with the outcome? Will there be room for appeal?
On the agency, I don't think any of the parties would say we want to argue on the interim relief because the relief is interim anyways. But I think there's still going to be another very long and projected battle in terms of Part B, in line with what ought to happen or may happen on the 19th of January. So there is room to go a step further. But I don't think either of the parties would want to traverse on that one. It doesn't really make any prospect, because if the president loses on Monday, there's not going to be enough time in order for you to file an appeal so that you don't appear on the 19th. So on the basis of time, I don't think that's going to be successful. And if the former president also loses on that day, to file an appeal so that you force the president to appear on the 19th is not going to make any sense. So yes, there may be an appeal, technically speaking, but it's not going to be a prudent move.
I appreciate your time and insight into this. I'm so glad someone like you can explain it to someone like me. It's difficult to keep track sometimes. Attorney Mpumelelo Zikalala from Zikalala Attorneys. No doubts we'll get him back on again. Wonderful analysis as to how we are at this point with this court case, as it's the current president and the former president going head to head in court.